Thank you. My Lord, we are saying two things, and I quite agree with you. We are saying first that if we follow what's on the face of Article 257, it is possible for Wanjiku to achieve. It is onerous but possible. But what is in 257 is what is being supplanted by the decision of the court. It is onerous but possible. It is this line by the decision of the court that would be impossible to achieve. But if we follow what's in Article 257, it is possible to achieve with the ultimate end that Wanjiku will put the final stamp in a referendum. That is our submission. My Lord, just one word in terms of verification. In terms of verification, my Lord, what IBC is required to verify is 1 million registered voters that they support the initiative, not 1 million signatures. My Lord, the court goes to an earlier document which talked of signatures without noting that the wording of Article 257 changed from 1 million signatures to 1 million registered voters. Our submission on that, without going into too much detail, is that the court was obligated to look on the express text of the Constitution as it is now, not on the contents of an historical proposal that was rejected.
How do you verify those voters? I mean, supposing someone were to go and pick 1 million names who are on the register and present them, how does IBC verify that indeed those people are supporting that initiative? How do they do that?
Thank you, my Lord. My Lord, that issue, and I invite you, I thank, thankfully, that analysis is made in the Justice and Legal Affairs report at page 28. My Lord, we will see from that report that the IBC stated that it uses what it calls unique identifiers. That in our system right now, you are not just identified by your signature. There are other unique identifiers. And when my Lord then consider that report, you will see that the question of signatures was only one of the others. In our situation, my Lord, and especially in this context, it is to be noted that there were over 4 million signatures. Not a single person, despite the publication by ABC, came out to complain that my name was put there erroneously.
Counsel,
yes, my Lord.
Please assist me. You see, it's my business to understand this thing. And I want to know, how is that process a verification, other than just having the numbers and perhaps ID numbers which are easy to get from IBC, from the voters register? How does one verify that those are actually supporters? This thing called unique identifiers. Sitting here, I have absolutely no idea what that is. What are those unique identifiers?
My Lord, for this context, and without going to the theoretical aspect because of time, in this context, the submission by IBC, which is captured in the JLAC report, is that once the supporters come with a list of names, the IBC then publishes it to the public, just so that in case it is alleged that a name was included wrongfully and it is not you, then you would complain. That way it would verify and check that that name is wrongly put there. The
Counsel,
yes, my Lord.
Parliament may have been quite happy to be told by IBC,
yes,
we have unique identifiers and they don't follow it further. But for me sitting here, if you tell me that there are unique identifiers, I need to be satisfied, and that's what I'm asking you. What are those unique identifiers?
My Lord, my learned friend, Professor Gidu Mugai, says they'll deal with that. Because of my time, I will not go into the detail. What is sufficient for this purpose, my Lord?
I'll wait. Yes. Thank you.
Is that you cannot place undue substance on the question of signatures when in the first place the law does not require every Kenyan to have a signature. When in the second place there is no repository of signatures, and that the undue elevation of the question of signatures when it's not required is what's wrong. But I'll allow the team from IBC to deal with that. My Lord, on the question of quorum, it was dealt with. All I wish to say on it are two quick things. One, that, my Lord, you cannot elevate a provision in a schedule of an act to essentially amend the Constitution by providing a higher minimum number of commissioners than is provided in the Constitution. But secondly, my Lord, you will also note that this matter had already been dealt with by a court of concurrent jurisdiction, that is Justice Okwan, and that is on volume 1 of page 133, where the court affirmed that the IBC had quorum. And what's important, my Lord, is that the Superior Court in this case paid no difference to that finding. My Lord, lastly is on the question of multiple questions, and I just want to submit very quickly, my Lord. One, that the entirety of Article 257 in terms of the bill deals in the singular. And my Lords will see from sub-article 1 to 10, it says there, it. In all those instances, it refers to the bill, not to the questions. Because whatever suggestion you have under Article 257(3), you must reduce it to a bill, a bill.
Counsel, I'm at 257 with you. 257(1), is it dealing with a bill or is it dealing with an amendment?
My Lord, let us go through 257 from 1 to 3. 1 is the one that gives the avenue of amendment by popular initiative, an amendment, to distinguish it from the one by Parliament. Under 2, it allows two possibilities. You can come with a bill, and where you get it is irrelevant. Or you could come with a suggestion or suggestions. But if there are suggestions, and that's the important aspect, you cannot bring those suggestions to a referendum. You must reduce them to a bill. Okay? Under 3. And the word is shall. You shall formulate it into a draft bill. Not draft bills. A draft bill. Whatever it is. And we can demonstrate that. My Lord, when you continue, and even the question that was posed yesterday in sub-article 10, whenever you talk of it, there, it refers not to a question. And Learned Senior Mr. Rengo submitted on this yesterday. The rosy idea that you can bring questions to a referendum is one that arises from the Elections Act, Section 49. And it allows the possibility that you could pose a question, should Kenya still remain within the East African community, as a question. But when it comes to an amendment, there is no such latitude. You must reduce it into a bill, and it is that bill, a bill, the bill that is considered. It does not allow of the possibility of multiple questions. The corollary to that, my Lord, and I invite you to look at the finding by Justice Ochieng in the case of Titus Azlila, Volume 6, page 2650, all the way to 2656, where he makes two important findings. One, that Article 257 itself is a complete framework. It does not require anything else to enable it. It is complete. And in fact, he goes ahead to find that to try and direct IBC on how to undertake a referendum is a usurpation of their jurisdiction.
Mr. Otiende, do you still intend to give your other counsel 20 minutes?
I am now 2 minutes and I'm done, my Lord. I think it's the questions that 2 minutes. My Lord, it is also to be noted that the court failed to take judicial notice, although it was submitted, that there is a referendum bill. And that referendum bill is produced in the reply to the additional evidence. And in detail, without explaining, it demonstrates why why Parliament adopted the view that you cannot have multiple referendum questions. Indeed, my Lord, if you were to accept that you are to have multiple referendum questions, then it cannot only be for the voter at the referendum. Will you have those multiple referendum questions to the counties? Will you have them to Parliament when they are considering it? The answer is no. It would result in unimaginable difficulties, and you would not have a constitution. My Lord, lastly, is to say that the JLAC report that is annexed is not a finding as submitted by the respondents, but as shown on its face, they are notes which were meant to assist members of Parliament in making a determination whether to vote yes or no, and they are notes that contain the majority view of parliamentarians and the minority view. And it is a document that did not require and was not adopted by Parliament. It is of no probative value for this discussion, except for academic purposes. But to that extent, and all this is captured in our reply, on all 8 material points that the court found on, the JLAC report found to the contrary. My Lord, I now wish to invite my colleague, Senior Counsel Lucy Kamboni, to continue. Thank you.
My ladies, thank you very much. Firstly, it's a plea for 5 minutes because I have been gesturing there. I thought your Lordship will ask me whether there is something wrong. A question would be asked by the bench and the clock would not stop. That is why 5 minutes have disappeared. So, my Lord, if you could restore that. Otherwise, all I will do is greet the bench.
Council, it's nice to greet us, but I think it's important to realize that your submissions are all in place,
yes,
and your time really ought to include a time for intervention. The idea is to persuade us,
yes,
and we need to ask those questions.
Thank you, my Lord. I will try my best. My Lord, firstly, I'm dealing with the issue of public participation, and I will pick up from where my learned friend talked about the role, what a promoter does in a popular initiative. And I will not rehash that. But your Lordships, if you look at part 4 of the decision, that is from paragraphs 562 up till 568 or thereabouts, you will see that the court deferred to the form of public participation that was determined or that was recommended by the petitioner. And you will see that the court says in paragraph 566, we have considered the respective parties' arguments on this issue. Honorable Raila Odinga and the BBI Steering Committee did not even suggest that copies of the reports and the Constitution of Kenya Amendment Bill were provided to the people, and in the form the petitioner insists the law requires. Now, your Lordship, a promoter need only get 1 million supporters. The promoter doesn't have to go to all the majority of the 24 or of the 47 counties in this country to get support for the initiative. They need 1 million voters to support their cause. So if they can choose where they will go, and therefore to insist that this promoter must carry out public participation in the manner that the court has insisted in the High Court doesn't make sense. Because it means that if I know your Lordships, you will support my cause as a promoter, I will come to you and explain to you what it is that I intend to do, and you will support me. And I will go to a locality that I know, again, I have support. So how is it that the High Court insisted on public participation in the manner we insist on public participation when we are dealing with policy decisions and amendment of statute of law and that kind of in coming up with legislation, policy issues. How would they insist that a promoter carries out public participation before they come to a supporter to say, support my cause? Your Lordships, that doesn't flow. And in particular, when you look at the finding of their Lordships, this is in the holding, this would be 13, they made a declaration that county assemblies and parliament cannot, as part of their constitutional mandate, consider, yes, they cannot change the content of such a bill, which means then that in this particular instance, it is a different scenario. When I come to a supporter, my cause, and when this bill is presented before the assembly, the county assemblies and parliament, in fact, nothing is altered. So then how would I be seeking public participation if, in this respect, if you cannot even propose an amendment to this bill? That is the challenge that we find in the decision that a promoter carries out public participation. But in any event, your Lordships, at the county assembly, once the promoter is done presenting their bill for the popular initiative, once they present it to the assemblies, to the IEBC, and that finds its way to the county assembly and then to parliament, then at that level, there's public participation that happens, and there is a record of that having happened. So in our view then, a very high standard was raised, whereas a promoter is simply that. In fact, once the promoter is done and presents their document, that is the end of the matter. They need not carry out any, they don't carry out any public participation. They now begin to whip their supporters, and the different interest groups then come in, and then before the referendum, if that is where it ends, then there is the usual civic education that will happen. So really that is what a promoter does. Now quickly on some of the other issues that I need to address. Of course, I've talked about public participation under Article 10(2)(a). That is a requirement. Now, the authority, your Lordships, I would wish to emphasize is that of Republic versus County Assembly of Kirinyaga and another, and this was a decision by Lady Justice Nyamweya, and she does an excellent. She makes an excellent finding on what actually should happen in matters of when you are considering public participation in the context of a bill to amend the Constitution by popular initiative. She says the effect of lack of public participation can, however, only be determined upon the conclusion of the process, given the double decision-making processes that happen. So the prevalence or lack of public participation is a contributing factor, therefore, is looked at differently because there are different actors in the promotion and passage of a bill to amend the Constitution. So you cannot look at just one, you cannot just make one step. You need to look at the entire process because Parliament and the county assemblies are engaged, and that is what she therefore finds, and we urge you, my Lord, to look very seriously at that authority because it speaks to this situation. And it's on pages 2002 to 2016 of Volume 5. She also emphasizes that this is a process which is ad in continuum, and the parameters in each and every state vary. So you cannot even say there is insufficiency of public participation until, you know, the entire process runs through. Then you can assess whether there is adequate public participation. And as indicated, public participation will occur at the 47 county assemblies, in the National Assembly, in the Senate, and then IBC, possibly leading towards the referendum. Then, my Lord, sorry, I think I made an error somewhere. I should be referring. No, it's correct. My Lord, then the other issue to consider is that every case is looked at in terms of public participation. Every case is based on the peculiar circumstances. And in this regard, we refer to IEBC versus NASA. This is volume 10, pages 4601. You look at the mode, degree, and scope and extent of public participation in that manner. Now, my Lords, as I indicated, there is no intention to alter the contents of the draft Constitution Amendment Bill, and that is why this bill is different from regular legislation where we seek to amend. And then, my Lord, therefore to be distinguished from the cases we normally have on public participation, like Robert N. Gakuru. Now, there's this finding that in the absence of meaningful public participation and sensitization of the people prior to the collection of the signatures, the exercise was constitutionally flawed. That is a finding in paragraph 576 of the decision. And as I've indicated, my Lord, the role of the promoter is simply that. It cannot be that is the standard at which this aspect of public participation has been judged. No evidence has no evidence has been tendered also to show that public participation was not done at the levels that I've indicated. County Assembly and Parliament, yes. Then, my Lord, yes, my Lord, the other important thing is that the 1 million voters also show that the promoters actually achieved even what in the making of the Constitution we were unable to achieve. So that effort cannot be wished away, because in the making of the Constitution only about 100,000 memoranda were received. So an onerous standard therefore has been set for a promoter, which is not supported by Article 257. My Lord, my Lord, what we are also submitting is that it was important for the court to allow this matter to go to the referendum, because that is then where the ultimate test for the decision making then by the people is made at the vote. And as was indicated, even by the judges also in paragraph 471 of the decision, the WACO draft was rejected on that basis. So where was the danger then in not allowing this popular initiative to go to the referendum? Then, my Lord, as my time is also running out, I will now look at the matter of the fact that public participation also happened when notices were sent out, my Lord, for public participation, and that has been indicated, my Lord, from pages 8867 to 8868 in volume 18, and that went, of course, to the county assemblies, and also LSK was also involved. They also sent a notice for public participation to the members. Now, my Lord, I will now look at the role of the court because I am running out of time. And my Lord, our submissions is that, save for ensuring that the amendment process set out has been complied with, the court plays no role in the constitutional amendment process by popular initiative. And my Lord, we have mentioned the case of Law Association of Zambia and another versus Attorney General, and you will see that in our volumes. My Lord, the other issue I wish to refer to, my Lord, is with regard to justiciability and ripeness. And my Lord, we are saying that my Lord, we are saying that as at the time when these petitions were before the court, my Lord, yes, as at the time when these petitions were before the court, my Lord,
Yes, Counsel.
yes, my Lord, is a time that is running out. Yes, my Lord, we are saying that there is I think I will ask.
I think I've read your submissions, Counsel.
Yes, my Lord.
And I think perhaps the point you are trying to make is that at the time the petition was being heard, the bills were still before the county assemblies. And so the occasion for scrutinizing whether there was public participation was not yet ripe. Yes,
petition E282 was filed even before the process commenced. And therefore, as at that time, this particular matter was not ripe for decision, and it was therefore not justiciable. And then the other issue, my Lord, is with regard to the political question doctrine. And my Lord, where there is a clear constitutional commitment and mandate for a matter to be dealt with as by way of conventional political methods, your Lordship, then in those circumstances, the court would ordinarily exercise judicial restraint and allow that to go through. So in this case, my Lord, there is the decision by in the petition number 496 of 2013, where your Lordship, in a matter relating to a draft bill, the judge was reluctant to pass judgment on the hypothetical issues that were framed. So in this case, with 282 being before the High Court, it was not then proper for the judges to accommodate that and to make a finding that affected a matter that was pending.
Thank you, Senior Counsel. I think that's fine. Thank you very much. Your time is up now.
Most obliged.
Thank you. And I think we are now fully done with the second, third appeal, and that is Paul Mwangi the BBI Secretariat and the Honorable Raila Omolo Odinga. That's it. So, before we move to the next appellant, we will bring forward the health break. We'll take it at this time so that we come and start with the next appellant. So we'll adjourn now.